It is a real pleasure to see all seats taken. The Constitutional Court over the last couple of days has a real honor and real pleasure to welcome the judge of the International Court of Justice, Judge Trindade. I would like to tell you a little bit about him. I've mentioned already that to the judges and the staff members of the court that the reason we know each other is that Judge Trindade, Professor Trindade, is an old friend of the European human rights architecture. And he's been coming to the Council of Europe and notably also to the European Court of Human Rights at many occasions and giving inspiring talks and views on international human rights law. So this is how we know each other. Professor Trindade has published over 700 extended research pieces and has published, I believe, more than 50 books. So you, young generation in this audience, you have a goal now to achieve in the area of legal science, whichever science area you have chosen. I'm very happy that Judge Trindade is the member of the International Court of Justice, now already for a decade, and has been elected for another term. Before becoming a judge at the International Court of Justice, he was the judge of InterAmerican Court of Human Rights, and in fact presided the Inter-American Court of Human Rights. And I can tell you also as a scholar and having had a chance to observe the Inter-American Court from the Strasbourg perspective, at the time you were presiding the court had really gained strengths in what the court said in the judgments. There have been a number of areas where the Inter-American Court of Human Rights was the first one to decide on an issue, where the European Court of Human Rights, in fact, got to deal with the issue later, like disappearances, which we faced for the first time in Cyprus due to the armed invasion of Turkey. We got the inspiration from Inter-American Court of Human Rights jurisprudence. I remember how difficult the case of Varnava against Turkey was. And luckily, because at the beginning I was fighting for another view, which in the end turned out to be a majority view, very good, but that was thanks to the possibility to rely on the Inter-American Court's jurisprudence. And it's absolutely fascinating to see how these two courts in Europe and in the Americas have been helping each other along the way and actually have been the leading institutions in strengthening international human rights law. So that's yet another reason I'm very, very happy to have you here in Riga, and we are happy to also to share with you a little bit of our country, the country we really love, and the country we put our best efforts to make it develop in the future. So, dear Antonio, you have the floor.
Well, Honorable Justices, Madam President, professors, ladies and gentlemen, it is a great satisfaction to me to be here in your lovely country and to share moments of dialogue with all of you. I have always been very much attentive to the countries of the region, and I also am very much open to different cultural manifestations, and I have learned through our dialogues of yesterday that we share the same fundamental support for jus naturalism. So I'm extremely happy that I found this affinity also here. No? And I would like to take up this occasion to share some reflections with you on our topic, which is the common mission of international tribunals. I also would like to express my satisfaction to meet again Madam President Ineta Zemile. We know each other for many years, so it's a great satisfaction to me now to meet her and all of you here in Riga. So I propose to give you a general outlook of the work of international tribunals. I have been very much attentive to them all. I very much believe in the dialogue among international tribunals and on the importance of harmonizing the case law in pursuance of a common mission, despite the fact that we all have, all tribunals, distinct jurisdictions, but the mainly objective is the same, the realization of justice. So I will start with the prehistory of international tribunals. I hope you don't mind if I sit down, because it's a dialogue, it's an informal conversation. No? So, in fact, if we look at the history of international tribunals, it's over 1 century. But actually, the thinking about international tribunals is older. And I have gone through the writings on the subject, and the first author who really thought of the need of an international tribunal was the Abbé de Saint-Pierre. Abbé de Saint-Pierre, he dreamed of one in his project for perpetual peace in 1713. And then shortly afterwards, he was followed also by another thinker, Immanuel Kant. Immanuel Kant, also in the 18th century, in 1795, they both thought of the need of an international tribunal in order to sustain international peace. And then later on in the 19th century, you had authors like William Ladd and Gustave Monnier that also thought of a future international tribunal. And so by the time that the idea came to actual creation of a tribunal, we counted on these authors already. I have contributed to the creation of a museum there at The Hague of the history of international tribunals, inaugurated 2.5 years ago, in which we found documents of the writings of these authors. And actually, the writings of Monnier, they were forgotten for many decades. And it was at the time of the Franco-Prussian War that he presented his first ideas. But it was very much, his writing was very much dependent on state voluntarism, state consent. So this is the reason why the main contribution of Monnier was on the collective guarantee and international humanitarian law, of course, and he belonged to the generation of jurists who created the Institut de Droit International. No? But his project was only revived by the time of the establishment of the Nuremberg and Tokyo military criminal tribunals, and especially in the 90s with the creation of the ad hoc international criminal tribunals, then especially the Red Cross started republishing all the writings of Mounier after decades of oblivion. And we, in fact, commemorated in 2007 the centenary of the Second Hague Peace Conference. And in this peace conference, they tried to create an international tribunal, the International Prize Court in 1907. But this had never had the sufficient number of ratifications to enter into force. So this tribunal never saw the light of the day. It was on paper mainly. But in that same year, in the continent I come from, an international tribunal was created, the Central American Court of Justice, among the 5 states of the Central America, and this tribunal lasted for 1 decade, 1907 to 1917. And during this decade, this tribunal received 5 cases from states against states, and 5 cases, an average of 1 a year, therefore, of individuals against states. And this tribunal, I have a picture of the judges of this tribunal in my office at the ICJ, and this tribunal always decided in favor of these individuals in the 5 cases, and so by the time that the first decade ended, they never renewed the convention which created this tribunal. So for 1 decade, it functioned, and it was very avant-garde, very forward-looking, 1907 to 1917. So there was the idea of creating a world court, but the problem was that as the Peace Palace was inaugurated in 1913, then there was the outbreak of the First World War, and then this was postponed, the idea of a world court. In the meantime, we had another author, and Vespasian Pela, and he wrote in Bucharest. He is an author from Bucharest, and he wrote his very thoughtful book, La criminalité collective des États et le droit pénal de l'avenir. Collective criminality of states and criminal law of the future in 1925. And in his book, he took a step further. It's very impressive, this book. I have it in French. And he was the first one, really, to say that there are crimes of state crimes, not only crimes of individuals, but always state crimes. He was very courageous. So there was need to wait until the end of the First World War for the initiative to be taken to create a world court. In the meantime, in the 2 peace conferences also, they decided to create an arbitral tribunal, which was rendered permanent, which is the PCA, Permanent Court of Arbitration, which operates at The Hague, but as a court of arbitration, it's a list of several countries. Each country designates 4 members, nominal members, and then if there is an arbitration needed, then they choose among them who is going to be the arbiter, who are going to be the arbitrators. We have had recently cases which became very well known with lots and lots of people. A recent case, Sudan and South Sudan, for example, there were 800 people that wanted to attend the hearing, so we had to put screens around the Peace Palace at The Hague for them to attend the hearings, and even more recently, the cases of China and the South China Sea, the other countries of the region, also lots and lots of people. And shortly after the decision was announced, China said that it went ultra vires. And so it was difficult to give execution to it, to comply with it. But anyway, and we have had cases that presented problems in arbitrations, and they were taken before us. For example, East Timor against Australia. It was an arbitration. And all of a sudden, the lawyer of East Timor, he was in Canberra, and the documentation of the arbitration was taken up by the local authorities. And then East Timor required from us provisional measures of protection. You know, the same building, the Peace Palace, but different tribunals, no? And this was a fascinating request of provisional measures. I keep a good memory of it. And then we ordered that these documentation should be returned to East Timor. And I appended a separate opinion saying that they should not be kept by Australia, but should be sent to the court so that the court would take care of it and then return it to East Timor. As the court just said to give it back, I said, no, the court should give it back. No? But anyway, it was given back, but the whole arbitration was rendered impossible, no? Because the documentation was certainly became known to one of the parties, the contending parties. So before the coming into being of the World Court, the old Permanent Court of International Justice, what are the lessons that we can draw from this prehistorical period? First of all, the intermingling between international humanitarian law, the beginning of international human rights law, and international criminal law as well. And so, the complementarity, that's a very important point I would like to present to you, the complementarity between individual and state responsibility. They do not exclude each other. They do not exclude each other. They are complementary. So, international human rights law became concerned with state responsibility. International criminal law became concerned with individual responsibility, but they complement each other. For instance, I remember in the advisory proceedings of Kosovo, some 9 years ago, in the ICJ, one of the interveners said, no, we have already sent to the ICTY Milosevic and Milajic and Karadzic, so there is no need, the case is over, there is no need for the advisory opinion. But what was forgotten is that it's not only a matter of individual responsibility, but also of state responsibility. So this is a particularly important illustration that the two go together. One does not exclude the other. And there have been other examples along recent years. So by the time that the PCA occupied and started functioning regularly in the Peace Palace at The Hague, an advisory committee of jurists was convened in order to prepare the draft statute of the Permanent Court of International Justice. And this advisory committee contained 10 members only, from different cultures around the world, different legal cultures. And it was presided by one country of civil law, jurist, Baron de Caen, and he was a justnaturalist. So he presented his own views for the future statute, but then he was objected strongly by a just-positivist, Elihu Root from the US. No? And so the solution was found by someone who was in between, Lord Fillmore. So he tried to find a solution in between natural law and positive law. And Elihu Root is the one who insisted against the initial project of the Belgian president of Baron de Caen of emphasis on treaties and custom. And Baron de Caen and the other supporters of natural law insisted on the importance of general principles of law. And then Lord Fillmore said, well, let's find a solution in between, and that's why they drafted this Article 38 the way it is drafted. Now, as you all know, no? Treaties, custom, general principles of law, equity, and they regarded general principles of law as being a subsidiary, and which I strongly contested in my general course at the Hague Academy. I thought this was nonsense, because general principles of law are in the foundations themselves of international law. They are not only a formal source, but they are in the foundations of international law in my general course in the Hague Academy. Well, that's how this drafting was approved by means of a compromise, and the drafting of the reference to general principles of law recognized by civilized nations. I have strongly criticized that too, and I have supported the view that there are no civilized nations in the world. There are nations that behave in a civilized way while they do so. But there is no nation which by its own nature is civilized. I have written a lot about it, including in 2 of the books which I just donated to the library here. And I have pointed out the lessons that we can draw from so many thinkers, which are almost forgotten in our days, pointing this out. But this was the idea that was current in the early 20s, and that is the reason why this expression appears there in Article 38, which in my view is totally inadequate. Then this was anyway the final contribution. There are other aspects of the work of the drafting committee. They contemplated the possibility that not only states but other subjects of international law could bring cases before the World Court, before the PCIJ, Permanent Court of International Justice. But then the more restrictive view prevailed. Only states against states. But what happened? What happened between, or in the interwar period, between the end of the First World War and the beginning of the Second World War? Most of the cases that were taken to the court concerned minorities, people who had been displaced, were put in one country or another because of the change in the frontiers. So the court could not adequately reason within a strict interstate framework. So I can give you some examples. The advisory opinions on German settlers in Poland, 1923. Jurisdiction of the courts of Danzig, 1928, a very famous advisory opinion. Greco-Bulgarian communities, 1930. Access to German minority schools in Upper Silesia, 1931. Treatment of Polish nationals in Danzig, 1932. Minority schools in Albania, 1935. So, yesterday I was commenting with some colleagues that even positivist judge of the old court like Anzilotti, he tried to rethink everything that he had written, and in these minority cases he adopted a much wider position, recognizing the rights of groups of people, minorities, and so forth, which is very much to his favor. Also, another judge of this court that I appreciate a lot, Max Huber, he has a lot to do with the international humanitarian law, the flourishing of international humanitarian law. And I found an autobiography of him that he has written, a rare book. Once in Geneva, I was there, and I bought this autobiography, and it's fascinating. His reflections on the importance also of natural law, and they cannot only consider interstate relations. So there was awareness, even in the times of the Permanent Court of International Justice, as to the need to go beyond interstate thinking or reasoning. And then the opportunity arose at the end of the Second World War with the creation of the ICJ. In order to avoid the problems with which the PCIJ came to the end of its period, a decision was taken to incorporate the ICJ to the United Nations, which they had not done with the old PCIJ in relation to the League of Nations. They didn't do this inclusion of the PCIJ in the League of Nations. But in the ICJ, yes, it became the main judicial organ of the United Nations. And then the president of the drafting committee was this time Badevin, a French jurist. And there was much hope that some changes would be made in Article 38 of the sources of international law. But there were also objections, and so they decided, well, keep the structure there. There were some drafting changes only, but no substantial change. And this is why the text that we have nowadays in 2019 is basically the same conception that prevailed in 1920. So 2019, 1920 is a century. So it's completely outdated, and does not reflect the evolution of international law. This does not mean that the court has to keep on maintaining the same mentality which prevailed in 1920. And I can give you some examples. For instance, these cases of Southwest Africa that created so much discussion in the 60s and ended up with the advisory opinion on Namibia. No? These cases brought to the fore the importance of resolutions of the General Assembly of the United Nations. But then the question was raised, but resolutions of international organizations are not included in the list of formal sources. So what's the problem if they are not included? Is the list of former sources of Article 38 exhaustive? Not at all. It's just an exercise which was made in 1920 by 10 jurists. The most restrictive of whom was awarded the Nobel Peace Prize. No? The most restrictive one won this Nobel Peace Prize. No? So the court itself, in these decolonization cases, it pointed out in several of its decisions and also in its advisory opinion on Namibia, it pointed out that the resolutions of international organizations are also sources of international law, contemporary international law. One cannot overlook them just because it's not in the drafting of Article 38. The court itself had to do that. That's why I think that this advisory opinion on Namibia is a contribution to the evolution of international law, and because it took this approach. And in fact, the General Assembly was so resentful in relation to the court in the 60s because of its very strict approach in the contentious cases concerning Southwest Africa, and South Africa, that this was the reason why they requested an advisory opinion, 1970, 71, and which was very much open to the progressive development and contribute to it of international law. And also, what another important point which became quite evident was that states began to be aware of the requirements of the rule of law requirements, as from the late 60s, early 70s. And so the strictly interstate dimension proved to be inadequate for the International Court of Justice. In my own outlook, I am a jus naturalist, but most of the judges of the court are still under this influence of jus positivism, and they still have difficulties to understand this need to go beyond positive law. I can give you several examples, recent examples, for you to think about. For instance, take the case of the atrocities of the Second World War committed by the Nazis in Italy after 1943 and in Greece, same period, 43 to 45. There was an agreement signed in Trieste between Italy and Germany then decided to bring the case to the court invoking immunities, because in the reasoning of Germany, the matter had come to an end in 1961 because they agreed on a lump sum amount to benefit the victims. But some of them never received part of that lump sum, especially those who became prisoners and who used to work in military forces, no? And but since there was an agreement, the agreement of Trieste, to refer the case to us, of course that no one would expect that Italy would raise any difficulties for Germany. But at the end of the written arguments of Italy, it decided to raise a matter of procedural law and presented an objection saying that according to their own view, they think that the matter was could refer back to 1943-45 and not as from 1961. Germany was very surprised, and then Greece decided to join the case as an intervener. I remember when we adopted a resolution that was something very forward-looking, you know, accepting the intervention of Greece. And so we had the presence of the three of them. And then what did the court do? The court decided that no, there was already this agreement between states, and that's it. It didn't pay much attention to the fact that some of the victims had not received anything of that lump sum agreement. Of course, I was a dissenter. I issued a very strong dissent. And you can see that in the website of the court, saying that this was a continuing situation, because in relation to those individuals that tried to obtain reparations, this situation started in 43 to 45 and continued until presently. But why did I did so? Because I took into account the rights of individuals as well, not an interstate reasoning. You see the problem with interstate reasoning. The fact that the mechanism is interstate does not mean that the reasoning has to be interstate. It depends on the nature of the case. So this is just one example. And just to show you the importance, no, of this case, there was another judge who also accompanied me, but he gave his own dissent. But it was minority, a very slight minority position. But you see, these individuals who felt that they have been injustice, they never have received any reparations, they tried to obtain a decision from the Supreme Courts of their own respective countries. And the Italians went to the Corte Costituzionale, and the Greeks went to Areios Pagos, their own constitutional courts. But this was not taken into account by the ICJ. I examined all this in my dissent. And in the two countries victimized by the Nazi occupiers, in the two countries, in both of them, the constitutional courts, the Supreme Courts, they found that they had the right to reparation. But with one difference. One difference. In the case of Italy, well, the court said that they had the right to reparations, full stop. So they were entitled to reparations according to the Constitutional Court, Corte Costituzionale. But in Greece, to execute the judgment of the Areios Pagos, they needed to have a request of the Ministry of Justice to allow the implementation. And of course, the Ministry of Justice of Greece never allowed it, because it did not want to have any trouble with Angela Merkel. Yeah? Then the court gave its decision rejecting the position of Italy, and then Berlusconi said, now we have to change this whole legislation not to allow the execution of the decision of the Constitutional Court. And then several people at the Hague were then breathing very, fortunately we solved the matter. But I said, let's wait and see. Then Berlusconi fell into trouble for other reasons that you know, and he fell himself from his position. And then what happened? A former judge of the European Court of Human Rights was not your colleague, President Zimmerli, but of a previous generation. But you know him. He passed away 4 years ago. And he and the president of the Corte Constituzionale, they prepared a decision rendering absolutely illegal this change which was made during Berlusconi's time. And so they said, yes, we are entitled to reparations. And shortly afterwards, about 4 years ago, the Constitutional Court gave another decision saying that these cases like this have to be based on general principles of law, such as those found in the Italian Constitution and this was, I find it extraordinary, and in the United Nations Charter. So at The Hague, I breathed very tranquil, very happily, and my colleagues who had earlier on breathed tranquil, they're not so tranquil anymore. And then I told them, now you have to sleep with this matter. No, I'm very pleased that justice has gone beyond the law. No? And now I'll tell you something very personal, because this is an academic meeting, so I can tell you. Shortly after that, I received an invitation from Distomo, from the mayors and the Museum of Memory and the mayor of Distomo in Greece. So I went there, and the families of those who were victimized by the Nazis, they were there. They are very emotional, much more emotional, the Greeks, than the Italians, because there it was worse than in Italy. It was terrible there. And then I visited the Museum of Memory, and they told me, we found justice in your dissent. They told me, I'll never forget that. And then 1 year later, the same happened. I was in a jury de thèse in Florence, and then the mayor of Civitella invited me, so I went there, same thing. The museum had been opened, Memorial Museum, by the families of the victims with the support of the mayor of the small city of Civitella. I didn't find that much emotion there, because they had different historical experience, but they were also very touched by the fact that the Constitutional Court had refused to allow implementation of the decision. So I think that my own conclusion on this experience is that law and justice go together. They cannot be separated, because if they are separated, then you don't have a judicial settlement of the case. No? And also at the time of the ICJ, there have been several occasions in which the matters brought before it concerned individuals or groups of individuals or peoples. For example, reparation for injuries advisory opinion 1949 had to do with people who rendered service to the United Nations, not to the United Nations as such. And also recent advisory opinions, for instance, last year we had the hearings, and in February this year we had the advisory opinion that will interest you on the legal consequences of the separation of Chagos from Mauritius Islands. It concerned the population of Chagos Islands. They were expelled by the country which took possession of it with the support of the United States. The United Kingdom took possession of it, expelled the whole population of these islands, and didn't give them housing, nothing at all. They are just abandoned in other islands, and they went to live in slums. There were cases of suicides, and they became extremely poor people. They no longer live on fishing as they used to in their own islands. And so this advisory opinion, fortunately, the court adopted an advisory opinion taking into account the situation of this population, this forcefully displaced, on the basis of General Assembly resolutions, like in the advisory opinion on Kosovo as well. No? And also there have been interstate cases, contentious cases that went well beyond the interstate dimension. For instance, the trial of Pakistani prisoners of war, 1973. This was one of the cases. The hostages cases, U.S. Diplomatic and consular staff in Tehran, 1980. The two cases of the Convention Against Genocide, Bosnia against Serbia, and then later on the case of Croatia against Serbia. The consular assistance cases, Breard, Lagran, and Avena, and the armed activities in the territory of Congo, which is a typically human rights case, 2005, and then since I joined the court, the obligation to prosecute or extradite, Belgium versus Senegal, the Hissène Habré case, and the case of Diallo, Guinea versus DR Congo, the case of jurisdiction immunities of the state, the one I mentioned to you before, Germany against Italy, the case of the conventional elimination of all forms of racial discrimination. This is a case of Georgia against Russia. There's another case in which I gave a strong dissenting opinion because the court just dismissed that case on the strict interstate reasoning, and I presented a solitary dissenting opinion saying that the court could not have interpreted the compromissory clause as if it was a compromissory clause of a treaty concerning another subject matter completely different. No? And what happened shortly after that? Shortly after that, Georgia brought its cases against Russia in Strasbourg, in the European Court of Human Rights. The same Ukraine against Russia. Several cases in Strasbourg. So this brings into the fore what I was mentioning to you, no? The common mission of all international tribunals. No? The fact that a case has been taken up before a tribunal does not mean that it cannot be taken up before another international tribunal. I mean, of course, the contending parties, they will not take it up in another tribunal in exactly the same way. I mean, the contextual considerations will be slightly different, and this has happened also in other courts, in other international courts. So the case has been taken up. Also, Love the Sea Tribunal in Hamburg has cases which, in relation to other aspects, are taken or have been taken to other international tribunals. So what are the lessons that we can draw from what I have said so far? There is an expansion of international jurisdiction nowadays. No, there has been an expansion of international jurisdiction. The fact that we don't have really a court, really world court that binds all states, does not mean that jurisdiction was not expanded. I mean, the conjunction of all the jurisdictions, they expanded to different domains of international law. And that's the way that jurisdiction has been expanded. I remember there have been two occasions on which all international tribunals met. One, it was the cinquentenary, 50th anniversary of the Court of Justice of European Communities, nowadays European Union, in Luxembourg. I went there as president of the InterAmerican Court in 2002. And the second one was in Managua, in Nicaragua, because it was funded this time by also the European Union in Nicaragua. And then all tribunals sent representatives. That was in 2005. Now, in 2002, something very interesting happened in Luxembourg. I remember that, and I mentioned this in my general course of the Hague Academy that I donated to the library today. The president of the ICJ at that time, Judge Guillaume of France, he proposed that in case of non-compliance with the judgment of any international tribunal, they could appeal to the ICJ. And we all raised our hands, the presence of all the other tribunals that were there, and disagreed with him. Because the jurisdiction is different. There is no hierarchy between international tribunals. They are coordinated. It's true that the ICJ is the main judicial organ of the United Nations. But this does not mean that there is a hierarchy. So this proposal was mistaken. And at that time, in 2002, there was a big problem between Strasbourg and Luxembourg, between the European Court of Human Rights and the Court of Justice of the European Communities of Jurisdiction. And then they celebrated, in this meeting, they celebrated a compromise, created a commission, a dialogue commission that was kept on paper for years, and they were trying to understand each other as they still are today. This does not mean that they fully understand each other, but they try to understand each other. But anyway, this expansion of international jurisdiction is not an isolated phenomenon. Linked to it is the expansion of international responsibility. What I mentioned earlier on to you, international responsibility of different subjects of international law, not only individuals, like as in criminal law, but also states, as in other domains of international law. And also, in the case of individuals and groups of individuals and peoples, then there is a jurisdiction for them as well expanded, in different cases brought before different international tribunals. Now, I would just, I'll briefly refer to the common mission of tribunals which operate in the same domain of international law. You have in your hand, on one hand, the international human rights tribunals, and then you have international criminal tribunals. Now, international human rights tribunals, they deal with state responsibility. International criminal tribunals deal with individual criminal responsibility. But it is very important to keep in mind that the first International Human Rights Tribunal, which started to operate in 1950, the European Court of Human Rights, was preceded historically by the Nuremberg and the Tokyo criminal tribunals, military criminal tribunals, but they are entirely different. Now, I will not here extend on the drafting, on the adoption of the European Convention and the adopted jurisdiction of the European Court, because it's not our purpose to extend on details. I have read all the travaux préparatoires. It's 9 volumes in the case of the European Court and the European Convention. But there was some changes of views also there, you know, and the original idea was to create the court without the commission. But then at a late stage of the drafting, then they decided all of a sudden to create an intermediary organ, which was the old European Commission on Human Rights. But then I remember when it became a permanent court in 1998, I was present in Strasbourg, representing the Inter-American Court. When the Protocol 11 was finally adopted, there was a formal ceremony in the Palais des Droits de l'Homme in Strasbourg. It was fascinating, you know, the speeches, and some of the old members of the European Commission were crying, you know, because their organ would have a survival period, a short survival period, but then would disappear. No, they were really emotional. But then they decided that some of the judges of the new permanent European Court would come from the Commission so that they would not cry too much. So they created an association, l'Association des anciens membres de la Commission, no? Yeah. And they started to live nearby, all of them, in Strasbourg, and anyway. And this was a fascinating period when we started the dialogue between the Inter-American Court, when I took the presidency of and the European Court, which remains until today. I'm so happy that it's been kept. No? And so, in the case of these human rights tribunals, they came quickly to the conclusion that jus necessarium is far more important than jus voluntarium. So the idea was to abandon these ways of acceptance of the jurisdiction of the court. It became automatically accepted, you know, it was obligatory, and that's in the case of the European Convention as to the European Court. As to the Inter-American Court, well, you don't have any declarations of acceptance, nothing putting reservations, limits, because we never accepted that in the Inter-American Court. But we don't have direct access, as I wished, no, to the Inter-American Court. It's through the Inter-American Commission. But there is one explanation for that, the fact that certain countries of the region have not ratified the convention. Countries that are not very much attentive to international law, you know, like the United States, some of the Caribbean countries, and even to my surprise, Canada also. They never ratified the American Convention, so they like to teach international law to others, but they don't assume any serious judicial compromise for themselves. So, in this meantime, there was a resurgence, a reawakening of international criminal law in the 90s. So there was a period of oblivion almost of international criminal law, and most of the people who write nowadays about this, they say that this was due to the Cold War. That's what they say. And so it was when Cold War came to an end, so to speak, came to an end, then this was the time when the two ad hoc international criminal tribunals, they were established in 1993, 1994. The first, the one for former Yugoslavia, and then the one for Rwanda. Well, their advances were unforeseeable, but they really contributed a lot to the development of international criminal law. This is widely recognized today. You know it anyway. I'll just summarize very briefly. In the case of the ICTR, the first international ad hoc criminal tribunal to condemn someone for genocide, no, a Cayesu case, and also the importance of its decisions in relation to gender approach, no, crimes of genocide involving also rape, and there was nothing before about that because Nuremberg and Tokyo had not touched on this matter. So this was an enormous contribution, and in the case of the ICTY, well, also shortly afterwards, genocide on other bases and in different contexts, and more recently in the case of Milagic and Karadzic. And the greatest contribution, in my own view, was their endeavors to put an end to impunity, because they selected those top level authorities that would be indicted, and there were condemnations. No? For instance, in the case of Rwanda, former prime minister, and in the case of ex-Yugoslavia, well, top military, no, Milosevic died during his trial, but top military figures like Karadzic and Milagic. Also, they contributed to the primacy of rule of law at both national and international levels. And it is very important to point out that it was after they started adopting their judgments that in 1996, for the first time, the General Assembly started devoting resolutions to the importance of rule of law, and pointing out the fact that it makes no difference between rulers and ruled, that everyone is subjected to law, is to be judged for any breach of international law, which applies directly to states, international entities, and also individuals themselves. And in literature, unfortunately, some books started appearing, writings using a very inadequate language. For instance, I hate this expression, proliferation of international tribunals. It's very derogatory. There is no such a thing as proliferation of international tribunals. What exists is the expansion of international jurisdiction. This is a derogatory language, and especially most of these writings, they come from North America, you know? And also a very bad expression, ridiculous, that comes from the critical legal studies group, fragmentation of international law. There is no fragmentation of international law. That's an absurd. That's a ridiculous expression invented by them, and it has done a lot of harm to doctrine. And anyway, as for my own experience, my large experience with the Inter-American Court of Human Rights is, there is an account of it in one of the books which I donated today, My Memories of the Inter-American Court. And I think the most important advance was, for instance, in the matter of reparations, the diversity of reparations, all sorts of reparations, and also provisional measures. We advanced a lot in international law in the matter of provisional measures in the Inter-American Court, reparations and provisional measures, and I wanted to thank kind words of President Zimele at the beginning of this session, and also the adjudication of cases involving grave violations of human rights with numerous victims, such as the cycle of massacre cases. And in these massacre cases, we adopted a technique which was very much practical, and it worked very well, which is the following: that if you cannot see how many victims there were, and we include in our judgment those who have already been identified. But if in the future there appears to be another one identified, then this person has to present herself or himself before a national authority of a special entity created for that, and has to identify himself or herself before this authority, but indicating that the facts which accounted for the injuries are the same as the ones that formed the judgment, no? The case adjudged by the court. And another important point of our case law was the centrality of the victims. The victims acquire a central position in international adjudication. Well, recently, since I have been living at The Hague now for 1 decade, I have accompanied very attentively the end of the era of the ad hoc international criminal tribunals. The ad hoc international criminal tribunal for Rwanda closed its doors in 2015. It was preceded by another one, Sierra Leone, which closed its doors in 2013. But Sierra Leone is not exactly an ad hoc. It's a distinct tribunal, hybrid tribunal. And then the other one, which finished more recently its work, closed its doors at the end of 2017, is the ICTY, former Yugoslavia Tribunal. And this coincided with the time of the establishment of the International Criminal Tribunal, a bit earlier on, of course, since the Rome Statute of 1998. And these two tribunals, when they came to an end, that end was preceded by a series of colloque, symposia on their legacy. And I obtained the books of each of those symposia. I asked, since I'm at The Hague, I'm interested in all international tribunals. I got all these symposia which took place in either in Africa or in the Balkans. And the major preoccupation was whether the archives should be sent to those regions. And I had a couple of judges in both tribunals that are friends of mine, and we had lunch together in the Peace Palace, and they asked me what I thought, and I told them, look, it's an absurd to send the originals. No? I think the originals should be kept with a residual mechanism, but there are copies, on digitalized copies. You don't know what's going to happen in the near future. You don't know what's going to happen anywhere in the world. So keep with the residual mechanism, keep the originals and then send exactly the same document in copy to Arusha, to Sarajevo, to Zagreb, wherever, no? To Kosovo, wherever. But and they thanked, and I think that for the moment they were first thinking of saying, but now that's what they are doing. That's what they are doing. There were two cases which were about to end. In the ICTY, they kept some judges there, but now all the judges have gone home, except the Italian judge who kept his flat at The Hague. But also he went back to Italy, but he kept his flat at The Hague. But anyway, the ICC. Well, the ICC tried to move ahead and to give more attention to certain points which were overlooked when the ad hoc international tribunals were created. Which were those points? First, the participation of victims themselves. This was not very commonplace at the time of the ex-Yugoslavia and Rwanda tribunals, although there was some attention to them, but much more attention now is given by the ICC. And secondly, reparations. They became much more active to foresee some form of reparations to the victims. The problem has been that this question of reparations has not yet been solved, because victims are too many, and they don't know where these reparations will come from. And also participation of the victims, yes, there has been, but they think that it's not yet fully resolved, and they have found some difficulties. So these are the dilemmas facing the ICC nowadays. I received the visit, I was commenting with my colleagues from the Constitutional Court here, of the African Court, ECOWAS Court, and I asked them what they thought of the creation by means of a protocol of a criminal chamber in the African Court on Human and People's Rights. No? I asked both them and before that the African Court on Human and People's Rights what the Africans had in mind, what they were thinking perhaps in the future to bring cases concerning Africans before this chamber and no longer before the ICC, because you have seen that there have been some withdrawals, no, from the ICC recently, 3 of them, and they are threatening, no, to anyway. And they told me that it's not certain yet, they don't know yet, they're thinking, but they said at the moment nothing has been decided about this. But anyway, they have created this possibility. So we have to keep this in mind. Also, since we are here in a dialogue, you have seen 2 weeks ago a very worrisome decision of the chamber of the ICC on Afghanistan, no? Because the ICC was strongly attacked by the US president, that offended all the judges and cut their passports, the visas to go to the US, and all that, and also the prosecutor because of the possibility that they might involve investigation of some of US militaries in Afghanistan. And now this chamber took a decision, I have read it, my God, 3 judges took a decision saying that there is no interest of justice to go ahead with this, and dropped the matter. I find this self-destructive, really. Very sad, very sad. So you have a look at it 2 weeks ago only. And then the president of the US proclaimed victory with this decision. No? So you see, we live in an extremely dangerous world at the moment. No? I haven't seen anything like that before. I would like to conclude, because I know that the time is limited. It's a pity because we could spend the whole day here. No? But time passes very fast. But the point which I have been insisting very much, the great relevance of general principles of law. Have a look at the advisory opinions on migrants, both the 16th advisory opinion and the 18th advisory opinions. I drafted them. I was president of the court, and it is entirely based on principles. The cases of amnesty, the amnesty law cases, the first one was the Barrios Altos case of 2001, and then when Antônio Cançado, whom I knew very well, was in the, first of all in the ICTY and then in the Lebanon Tribunal, he referred to it as the groundbreaking case, saying that amnesty laws, self-amnesty laws, they are not compatible with the rule of law at national and international levels. The other point I would like also to bring to your attention, the unity of the law, the interaction between, this interests you a lot, you know, domestic law and international law, they have the same objective concerning the rule of law, and the contribution of international tribunals to the rule of law that since 2006 was included and came to be a constant element in the agenda of the General Assembly of the United Nations. I have already referred to the dialogue of international tribunals, and I just conclude the important point of the issues for the future. No? The issues for the future. It is clear that this classical, traditional interstate dimension is insufficient, even for a tribunal like the ICJ, that it is limited to complaints brought by states. There have been courts which have contributed to specific domains of international law. For example, an distinguished court, the Sierra Leone Special Court, was the first one who adjudicated case of conscription of child soldiers, no? Which is, according to them, in pure violation of international law. Now, the major issues will have a very important case at the end of this year, in November, case of collective reparations. I don't know how the ICJ will consider this case, and I will not comment on it because it's pending, but I'll just say that there are victims, there are hundreds of thousands of them. This was what happened shortly after the genocide in Rwanda, when the Hutus escaped to DR Congo, and then there was this conflict and there was a mass killing, no, between 1996 and 2003. It was incredible, never appeared in the press, the extent of the evils committed. No? The other point, the importance of the principle of universal jurisdiction, the relevance of the execution of judgments. There is a need for international tribunals to pay greater attention to that, to the execution, the proper execution of their own judgments. There is at the moment, but I will not dwell upon this for lack of time, but at the moment a little bit of insufficient attention on the part of distinct international tribunals to compliance with their own judgments. And the importance to expand the domain of international responsibility together with the expansion of individual personality and capacity. And in any case, I would like to finish on a positive tone, that the justiciable, those who have found justice or have sought for it, have increased the number considerably with the coexistence and coordination of international tribunals. So we are very lucky to live in a world where there are all these international tribunals which did not exist at all some decades ago. So thank you very much for all your attention.
Thank you very much, Mr. Trindade, for your in-depth presentation, an excellent presentation. Maybe we have some couple of questions we would like to pick up. Maybe somebody has anything to ask Mr. Trindade. Please feel free to just raise your hand and we'll give you. We'll need a time to ponder a little bit. It was a yeah. So I might have a question which I didn't manage to ask you before. What is, from your perspective, for a country as Latvia, when we look in the future, what should do Latvia to be more visible and successful in this rule of law domain? Because as you noticed today throughout our discussions with the Minister of Foreign Affairs and also with other people, that the rule of law, international rule of law, is one of our main security, so to say, advisors. And we also need to step in to promote this rule of law internationally. And what, from your perspective, could be the steps for Latvia, as many call, we are a small nation, what could we do to strengthen our role in all this international domain? Thank you.
Thank you very much for your question. Of course, I will not dare to say what Latvia should do, but I'll make a general comment in relation to all states. I have great admiration for your country. I'm being quite sincere about this. I have followed its positions at international level, together with also the other two Baltic countries, and the attention that it gives to international issues. Also, in the times I went to the United Nations, so I have a great affection for this part of the world and for your country. But what I think could all these countries do, countries like ours, the ones in Latin America, the ones here, the ones in Central America, is to be very attentive to all these issues concerning the rule of law. Also the statements to make at the General Assembly every year when this issue is discussed. Once a year it's discussed, and so to give importance, and it's already been done, but even more so, the other possibility is to, of course, to get closer and closer to international tribunals work, not the contentious function, but the advisory function. So that there is much that can be done, but a lot has already been done. Has already been done, and I have been very attentive to it.
Thank you. Thank you very much. Varbūt kādi jautājumi vēl latviski arī var uzdot, var mēģinās pārtulkot. Yes, one brave man.
Thank you for your presentation. My question is regarding the ICC. You mentioned this sort of a self-destructive judgment they have made in the past 2 weeks. So what would be your take on the future perspective of ICC? What do you think, what development regarding this judgment? Thank you.
Thank you very much for your question. I am worried about it. I'm worried about it. And I remember that in 2015, when Rwanda finished the ad hoc tribunal, then there was a meeting there at The Hague in which the Conference of States Parties, the African states were indicating that they would be reconsidering their position in support of the ICC. And then there was much tension there, but then afterwards, nothing. But you've seen that very recently, 3 of them. So, as for what happened 2 weeks ago, I was reading just before I came here 2 days ago, a statement which was made by 5 former presidents of the ICC, the ones that have presided it until now, all of them expressing their enormous concern about what this chamber has done for the future of the ICC. And so I think that to make an international tribunal to depend entirely on the will of states is really a problem, because it's the Conference of States Parties. How can a state which is not even a party to the Rome Statute, to the treaty which created the ICC, how can it exert such pressure upon it? So we live in a moment of deconstruction, and it is very sad. I would never have imagined a couple of years ago that we would go through this again. But it's like going back to a time in which international tribunals did not exist. I mean, it's very sad, So this reaction should come from the ICC itself. definitely, in the next conference of states parties. But if you read I imagine you have already read it, no? But it's no ground for it. There's no ground for it to say that it's in the interest of justice not to continue examining this case. So creating an objection for its own work which has no ground in its interna corporis. No? So the reaction, or the former presidents, they have already made their statement, which you can easily, all of you can see, and either they react to this or revise this decision of this chamber if it goes to an appeals chamber, whatever, or else they will have a very difficult time in the near future. I hope not. But anyway, thank you again for your question.
Thank you very much for your answer. Are there any other questions? Yes, please.
Thank you for your presentation again. Of course, it was very interesting and enjoyable. I remember your remark about the fragmentation of international law. You called it a derogatory term. So the question is, what should the international courts do in order to deal with the issue, or you don't consider it to be an issue at all? Like we have different bodies of international law, human rights, investment law, and I don't know, EU law, which is, these bodies sometimes don't seem to understand each other very well.
Thank you very much for your question. I think that this expression was the creation of a couple of people whom I know and with whom I totally disagree, which belong to the same school of thinking, the critical legal studies. They are not exactly jurists, they are political scientists. And so this should not be taken seriously, you know, because it makes no sense. You have seen a book organized recently by some colleagues from the Nordic countries, and I contributed that book, The End of Fragmentation. They simply disregard it as absurd. You know? And this was the creation. I know these people, and they talked to two colleagues in the ILC, and then the four of them just passed this, included it in the agenda of the ILC. What does it have to do with the work of the ILC? Nothing at all. Nothing at all. The International Law Commission is oriented towards codification and progressive development of international law. Is fragmentation a topic for codification? Nothing at all. There is nothing more alien to fragmentation than to codification than fragmentation. And is it linked to progressive development? It is a progressive underdevelopment and destruction of international law. So I think it's not to be taken seriously, it's to be discarded, and those who spoke about this and supported this, really, they are worth some pity you know, on our part. No?
Thank you. Thank you very much for your answer. Are there any other existential questions? Okay, we pick up these two, and then we...
Your Honor, thank you for a very insightful lecture. I would like to ask you regarding international environmental law. So we are now living in a situation where we have hundreds and hundreds of international environmental law treaties. And at the same time, we are seeing quite a radical degradation of natural environment all over the world. So the obvious conclusion would be that these treaties are not really delivering. Some of them are, but most of them are really, really soft. So do you see any role in this situation of international courts and tribunals in a situation where we desperately need rules? Because this is a question of justice, of equity, not just between the people who are around right now, but equity between us and people who will be around in 60, 70 years from now. So do you see any role of international courts and tribunals in creating rules which perhaps states are unable to create at the present? Thank you.
Thank you very much for your question. I share your concern entirely. There were some proposals of creation of an international environmental law tribunal, but they did not prosper. No? And this was mainly after the first evaluation of 20 years of the UNCED conference in Rio de Janeiro. No? But the fact is that other international tribunals can play a role. Some of the cases are related also to environmental protection. And I can cite examples from the human rights tribunals. Some of the cases, they are related, the harm suffered by individuals are related to environmental conditions which have deteriorated. Insofar as the International Court of Justice is concerned, very recently we had the first ever environmental protection case, which was, as you know, the case of Costa Rica against Nicaragua on the lagoon region and the damage done to the trees in the lagoon, because the Nicaraguans, the region was disputed, but then we decided that that part of the lagoon was historically always has been Costa Rican, and then there was the second part of that case, which was the decision as to reparations. And this, you find this judgment 1.5 years ago. Damage caused by Nicaragua to the Costa Rican lagoon. And the problem was that, I can tell you, because this is already decided, I gave an opinion, a long opinion, separate, not dissenting, but separate, because the decision was correct, in my view. The problem was that the ICJ, since Corfu Channel, only sees compensation. Only sees compensation as a form of reparation. Compensation in terms of pecuniary reparations. And in the case of environmental harm, I think one needs to go further beyond that. So in my separate opinion, I said that much more important than compensation to pay to Costa Rica, I don't know how many $1,000, it's ridiculous in my view. The important thing was restoration of the environmental damage, of the part of the region that was damaged. Restoration. But anyway, the court limited itself, and the title of the judgment is called Compensation Owed by Nicaragua to Costa Rica. Now, the good news is that a couple of months after this judgment, Nicaragua paid the compensation fully to Costa Rica, and the issue is now solved. But have a look at that decision, and you'll see that, yes, there is a role for environmental harm, reparations, in considering them in a wider perspective. And thank you for your question.
Thank you. Now we have our last question for today.
Good afternoon. Thank you for your lecture. My name is Anastasia, and you've made quite a bold statement, which leads us back to the question of fragmentation. Correct me if I'm wrong, I think the last couple of decades in international law were characterized by the creation of subfields of international law that sometimes come in contradiction with each other and create a certain legal tension. So my question is more of a clarification. Don't you like the name fragmentation? Would you prefer some other legal term like diversification? Or is it or are you denying the whole phenomena? So if you could clarify that. Thank you.
To me, thank you for your question. To me, the phenomenon is of the expansion of international jurisdiction. There is no phenomenon of fragmentation. This is an invention of a group of political scientists called the critical legal studies group. They are from the US and UK. Yeah, and so they created this word, and they even included it for reasons which escape my comprehension in the agenda of the ILC. But I spoke with older members of the ILC who are now retired, and they were indignated by the creation of this topic for the ILC. So to clarify very clearly, there is no such a thing as fragmentation of international law. There is an expansion of responsibility, jurisdiction, personality, and capacity. As this has taken place from the beginning by means of distinct jurisdictions, they have nevertheless a common mission. So nowadays we have means to settle disputes which were not existing before and were not even conceived years ago. So we should concentrate on this, on the settlement of the dispute, and not in trying to minimize or to discredit them. So fragmentation is a US-UK conception which has no foundation at all in international law, and it works against international law.
Thank you very much, Mr. Trindade, for your public lecture. We very much appreciate you being here. And thank you very much. Liels paldies, ka jūs visi ieradāties šeit. Tiešām prieks redzēt pilnu zāli. Lai jums jauka diena un tiksimies, cerams, arī citreiz. Thank you very much.
Thank you very much. Thank you. Thank you very much for your attention and the hospitality. You know, I will keep the best memories of my visit to Riga, and you know that you have a friend at The Hague. No? Thank you.